Well, hello and welcome to the Prints Live. This is Debayan and this is my colleague Neelam Pandey, who covers politics and BJP for the Print. And we are here to discuss, if at all, can Maharashtra Chief Minister Devendra Fadnavis and Deputy Chief Minister Ajit Pawar ace the floor test and prove its majority if the Supreme Court orders an immediate floor test. For the viewers and audience who are not well acquainted of what's happening at the Apex Court for the last 2 days, it's that the Supreme Court held a Sunday special hearing yesterday to decide on the petitions by Shiv Sena, Congress and NCP challenging the governor's decision to invite Devendra Fadnavis in the wee hours of the morning to form government in the state of Maharashtra. There is also a very crucial fact here. The petitioners have also challenged the letter which Devendra Fadnavis had written to the governor, staking claim to form majority, etc. But the crucial question is, can the Supreme Court order an immediate floor test? And if the Supreme Court orders an immediate floor test, and with an immediate floor test, we mean a floor test within 24 hours, if such a floor test is ordered, can Fadnavis and Ajit Pawar, prove their majority? One of the first contention here is, especially since both Mukul Rohatgi, who appeared for Devendra Fadnavis, and Solicitor General Tushar Mehta, who was appearing for the Union of India, stated that Fadnavis has support of 170 MLAs, and 170 MLAs was the one which was there in the letter. So let's just get some political dope on the matter from our colleague, Neelam Pandey, who will just tell us what exactly happened between Devendra Fadnavis and the governor on November 22 to November 23.
Yeah, thanks, Debayan. So first thing that we have to understand is that technically whether Devendra Fadnavis and Ajit Pawar, if they have the numbers on paper, yes, that is what they submitted to the governor, that they had the support of independents as well as NCP MLAs. That is something which is now being contested by Shiv Sena and Congress. However, one important thing to note is that as of now, technically Ajit Pawar is the legislative party leader. And in case there is a floor test, as you pointed out, if there is an immediate floor test, then he can definitely issue a whip, and if the floor test happens, anyone who will not abide by that will run the risk of getting disqualified. So that is one important issue that we have to keep in mind, that on camera and publicly, whatever the NCP MLAs might be claiming that they are with Sharad Pawar or they are not with Sharad Pawar, their vote is what will count as far as government formation is concerned. The second thing to note is the fact that a number of people have been pointing out that Sharad Pawar is the party leader and he has now made someone else as the legislative party leader. They have also said those who will not come back to the party's fold will be expelled. Well, they cannot be expelled technically because they have not taken oath as MLAs. That is something that is yet to be done. Another important point to note is the fact that BJP has been maintaining that Ajit Pawar is the legislative party leader. Officially, he has given them a list of all those MLAs who have sided with them. And if all those people on the day of the floor test, they will vote with BJP and NCP, Ajit Pawar's NCP, then definitely they can go ahead and win the floor. Aspect is why the floor test might not happen immediately. Well, one thing is that it is not a minority government as far as numbers are concerned. Technically, no one has been able to prove that it is a minority government. So the Supreme Court here will whether it wants an immediate floor test or not, something that you will be able to tell us, that what is it that the Supreme Court is going to look at.
So see, basically Neelam, as you pointed out, that an immediate floor test is something which the judiciary in general has always favored in such times of political crisis, whether it be Karnataka or Uttarakhand, whether it be Goa, from 1988 or whether 1994 to 2018, whether it be the Bomai case or it be the Karnataka case, the Supreme Court has always favored for an immediate floor test. That's very important also because there is a risk of horse trading of MLAs that happen, buying out of MLAs, which Kapil Sibal in a very subtle way hinted yesterday that the Solicitor General Tushar Mehta is perhaps seeking more time for something else, but not to prove majority. But there is one point which my colleague Neelam Pandey categorically mentioned, that Ajit Pawar is the legislative party chief. At least that is the fact on the paper. However, the councils for the petitioners, the trio Shiv Sena, Congress, NCP, has particularly attacked this contention in court, they have gone on record to say that all the other MLAs, like out of 54 MLAs of NCP, around 41 of those MLAs have, passed a joint resolution in which they have removed Ajit Pawar as their legislative party chief. And that letter was submitted to the Honorable Supreme Court today. However, in a very in a lighter moment, Mukul Rohatgi in court today said that what is this continuous clamor of I am NCP being represented by Mr. Kapil Sibal and Dr. Abhishek Manu Singhvi, whereas I am the NCP. ASG Maninder Singh was representing Ajit Pawar in court, and he categorically said that I am the NCP, so there is no question of someone else taking my case and the petitioners having NCP on board as one of the petitioners, etc. So this is what is happening in court. But if court orders an immediate floor test, there is also a problem of them not heeding to the accept and to the requests of Solicitor General Tushar Mehta, because Solicitor General Tushar Mehta has made a pleading request before the court that you cannot order an immediate floor test. Firstly, because if you order an immediate floor test, you're taking the role of the speaker, and if you take the role of the speaker without it being elected, then you are stepping into appellate jurisdiction, like you go into an appeal mode, which the SC cannot do. In fact, according to Solicitor General Tushar Mehta and Mukul Rohatgi, they are also saying that the court cannot order an immediate floor test because, it's a very interesting argument which they are saying that on November 22, Ajit Pawar indeed had 54 MLAs till the morning of 5:17 a.m. However, after that, God knows what happened. They are not saying that in court, but they are saying that if you order an immediate floor test, horse trading will win. So when, such kind of submissions are made before the court that horse trading will win by one of the councils, it is on record that they're agreeing to the fact that some of the NCP MLAs are indeed leaving the stable of Ajit Pawar and moving on to Sharad Pawar's side. And it was also well pointed out in court today by one of the councils that this is nothing but a case of family feud. One Pawar is with me and one Pawar is with him. It's like the two parties who are there in front of the court. One is the BJP plus NCP led by Ajit Pawar, and one is the Shiv Sena Congress and NCP led by Sharad Pawar. So this is like a family feud which is resulting into a big political drama. But here, Neelam, one question that becomes very imperative and important is, when we talk about this family feud of Pawar versus Pawar that is playing out in the courtroom also, which is divided, so how crucial do you think is this factor? Like, who is going to play the key card in this entire battle which is playing out with the nephew and the uncle, which is happening in Maharashtra politics?
And that is exactly a question that we have got from Cedric Vaz, who has asked, who is the boss in NCP, Sharad Pawar or Ajit Pawar? Something is not very clear. Well, to put it out very simply, as far as technicality and legality is concerned, it is definitely Ajit Pawar, because a legislative party leader is elected by MLAs. Party doesn't make him. It is the MLAs who elect the party, the legislative party leader. So he definitely has that kind of control over the MLAs. As far as Sharad Pawar is concerned, obviously he is the party leader as far as NCP is concerned. However, as I pointed out earlier also, in case there is a floor test, then it is the whip by Ajit Pawar which will hold true. It is that which the MLAs will have to follow. But at the same time, some of the sources are telling us also that what if all of them abstain?
So, I'm going to interrupt here because we have a question from one of our readers, Lalit Spam, and I think it's a question for you only. If a majority of NCP MLA don't follow the whip, do they all get disqualified?
Well, yes, definitely. If all of them if they don't adhere to the whip or issued by Ajit Pawar, they definitely run the risk of getting disqualified, which also means that it will pave way for elections again. And that is something which Sharad Pawar, Shiv Sena, as well as Congress has been maintaining, that we have the numbers. If we are not allowed to form government today and elections are held, if they are held even today, we will definitely be able to come back. However, as I said, there are technical issues concerned, there are legal issues that have to be taken into account. A pro tem speaker has to be in place, a speaker has to be in place for the floor test to take place. And as far as BJP is concerned, because of the numbers that the BJP has, the speaker will definitely be from the Bharatiya Janata Party, and which is why many feel that he is definitely, he's not supposed to, but as they say in politics, he's definitely going to be more lenient towards the Bharatiya Janata Party, and which is why they are likely to have an edge as far as floor test is concerned. Another important point to note here is the fact that in 2014 also, when Maharashtra elections were concerned, a number of MLAs abstained. And when these MLAs abstained, the total the number of the house, it comes down, and hence the majority that is required to reach consensus, that also comes down, and which is something also that the BJP is looking at. If strategy A doesn't work out, then they can always have a number of MLAs from different parties, whether it is Shiv Sena or Congress or NCP, to abstain, which will bring down the overall house number.
Absolutely. So, just adding to what you said when we were answering the question of Parimal, there's also the point which, she was highlighting the politics bit of anti-defection law, because under the anti-defection law, they're bound to get disqualified. There is no other way. However, innumerable Supreme Court verdicts have time and again proven that even if you are disqualified under the anti-defection law, of course, you can recontest elections. There is nothing like, you are disqualified from the party, hence you cannot contest elections again. It only means you're disqualified from the House as a member.
Exactly.
So under the anti-defection law, that has to happen, and that is what I think Mr. Sharad Pawar, who had a press conference immediately after Mr. Fadnavis took oath as a chief minister, warned his party members about. And he said that, if anyone is not abiding by or obeying the party orders, then they will have to face the acts of anti-defection law. So that is there. Now, we have a question from Mr. Squidward. Okay. Hey, everyone knows BJP has bought SC. So, of course, every decision will be in their favor. Ours isn't a democracy anymore, unfortunately. Well, we at ThePrint do not make any kind of comments on the judiciary or how it's supposed to be functioning, because, all said and done, all that you're saying are mere allegations. So when we are saying that a political party has invested money into the judiciary, that is a grave allegation for you to consider, for the judiciary to consider. So we are not at a place to...
These are the claims that are being made by the opposition.
Of course. But these are unsubstantiated claims, averse to interpretation. So we cannot answer it here. Abhishek Toshniwal asked, these kind of things happens almost every time government formation is in process, and everyone knows money is changing hands till some come. Still home come none of the times it is proved. So see, even the SC is aware of the fact, because SC has said that, horse trading happens. So how do you say, Abhishek, who invented the term horse trading? It is a very convenient and articulate way of saying that, to prevent buying off of MLAs, we are doing this. If you remember this Gayalal case, it was a very famous case in anti-defection law, which people know about, that he changed 3 parties in one single day. So that was the turning point of why the country needed an anti-defection law in the first place. So that also was a prime example of how this buying off of MLA happens. And as we speak today, the resort politics in Maharashtra has scaled new peaks, and that is happening. So absolutely, you're right about it, and it's indeed a worry that Supreme Court is hearing the case since yesterday, and it's been 2 days. There has been no order from the apex court, and whereas the top court knows very well that unless and until they give an order, the political stalemate won't be ending in the state of Maharashtra. So that is one very valid concern of yours. However, just to add here from the Supreme Court's side a bit, that this is not only a question of flow test.
Correct.
There are graver, larger questions of law involved here. Whether the governor acted in a partisan manner, whether the governor acted as a pawn at the behest of the BJP government, whether the governor was correct in exercising his power in calling the BJP government to form the Fadnavis NCP government to form the government, because there has been cases, whether the Karnataka case or the SR Bommai case, it has been held by the Supreme Court time and again that if there is a situation of malafide, and if there is a if there is an occurrence of arbitrary use of power by the governor, then governor is not immune to judicial review. So this is often asked, and we also have 2 questions on this. Like, what do you feel about the governor being immune to judicial review? So yes, Article 361 of the Indian Constitution indeed bars you from from charging the governor or laying any judicial scrutiny to his orders. But as the Supreme Court is the highest court of law, and under Article 141, they have time and again ruled that the governor's actions are not completely immune. If there is an element of corruption, if there is an element of malafide or excess use of power, the Supreme Court will have to step in. I think one question we have here for Yogesh Patil has asked one question. What about the statement of Devendra Fadnavis about not going with NCP in any condition few days back?
Yes, that is definitely a question that everyone is asking. The social media was abuzz with that because he had made a number of statements in the past. Devendra Fadnavis had made a number of statements in the past saying that he will never have any coalition as far as NCP NCP is concerned, they could never think of forming government with the support of NCP. And in the past, even Prime Minister Modi had talked about the corruption that the NCP is indulging in. But as it happens in politics, just like Congress, Shiv Sena and NCP, on one hand, Sharad Pawar led NCP, they decided to form government to keep BJP at bay. The BJP is also very much a political party, is now trying to do the same, putting aside all ethical and moral issues that are there. They are saying that we are doing this for the farmers, we are doing this to ensure we give a stable government as far as Maharashtra is concerned. And at the same time, they are also pointing out that Ajit Pawar felt that it was much easier to negotiate with one party rather than to form a party where there are three different stakeholders. Absolutely. And which is why stability was cited as a major concern by Ajit Pawar when he decided to go along with the Bharatiya Janata Party, with which, whereas they contested the elections against the BJP. BJP contested the elections against NCP. But these are political games that are, played. As far as in Haryana is concerned, for instance, the BJP decided to join hands with another party, with JJP, and they were supposed to be rivals at the same time. So, as far as politics is concerned, definitely over the past few years, we have seen two parties, even with different ideologies, coming together, as it was happening even in Maharashtra, Shiv Sena and Congress. So that is definitely a question that is a reasonable question to ask, but in politics, you never know what will happen tomorrow.
So, Neelam, it is not only in the world of politics, unfortunately, because in the Supreme Court also, there is a role reversal that happens with the lawyers. So, on Sunday, Kapil Sibal was arguing that political parties also have fundamental rights, because we should know that the petition that they have moved is under Article 32. Article 32 is only invoked when there is a violation of your fundamental right. So, they say there is an urgent need, etc., and there's a violation of fundamental right, and the petition was drafted under Article 32. When this was pointed out by Mukul Rohatgi, saying that political parties have no fundamental rights, and hence this petition does not have a locus, all that Kapil Sibal could do was give a smile, because Justice Sanjeev Khanna was on the Karnataka case bench when Kapil Sibal was on the other side, and he argued the very same thing, that political parties do not have fundamental rights, and under Article 32 you cannot move the court, etc. So even lawyers in the Supreme Court often has this role reversal, which Neelam was pointing out.
But do you think, as far as the floor test is concerned, that is something that all our viewers have also been asking us. Do you think tomorrow the Supreme Court is likely to take that?
Yes, I was just coming to that. Yes. Thank you for the question, because Supreme Court is very likely to order an immediate floor test, because if we peruse the order of the Sunday by the Supreme Court, the verbatim order was the need or the request of the petitioners to hold a floor test within 24 hours has to be considered. But it can be only considered after we peruse these two crucial documents, which we already spoke about. So that was a very important thing, and there are higher chances that the Supreme Court will order a floor test to happen in the state of Maharashtra. Now, whether it's within 24 hours or 48 hours is anyone's guess. There's a question from Pari Desai. Yeah, there's also this question. Anti-defection law says if two-third party breaks, then they don't disqualify. If two-third lawmakers disagree with whip, then how will they be disqualified? So see, there's a basic rule of disqualification law that, if two-third of the party does not agree with the whip, then there is no violation of the whip or the violation of the anti-defection law, because that essentially means that the party is merging with another political party if they're supporting another one, or, breaking away as a faction from one party. So in that case, you're very right, anti-defection law is not likely to apply. So you can do the maths out of 2/3 of 54. If those many MLAs actually defy the whip and support the BJP, then indeed they'll not be attracting the penal provisions under anti-defection law. Yes, so you were citing...
I was talking about Rishabh's question, why President rule was removed at 5:30
So that is one thing which is, again, everyone's guess, because President invoked Rule 12 of the Allocation of Business Rules 1960, saying that there was a grave emergency, and hence...
There was no need for the cabinet.
Yes, there was no need for the cabinet, and if you remember the 44th Amendment to the Indian Constitution with regard to the emergency provisions made it very clear that without cabinet approval, emergency cannot be imposed, and it was only done after Indira Gandhi declared that emergency in India. So when we talk about the 44th Amendment, that rule stays. But however, when we talk about the Rule 12 of Allocation of Business Rules, in case of the President, no such amendment is there. So that is completely to the discretion of the president. However, whatever president decides in the case of national emergency, etc., that decision needs to be ratified by the cabinet members at a later point of time. So it's not that the cabinet will not have a role at all. It potentially means that it has to be ratified by the cabinet ministers. So that's all about it. Because when we talk about how was the president rule imposed, you were sleeping, we were sleeping. That's the gist of it. Because at 5 a.m. or 5:17 a.m. the governor came to the conclusion that they need to be invited to form government, and by 5:47 a.m. I guess the president's rule was revoked, and that is how the entire thing fell out. So Rule 12 is something which is not being challenged in the Supreme Court as of now, and Rule 12 was the one which was invoked during the emergency era in the 1970s also. So a fairly rarely used provision. Yeah, Lalit is again asking, does the Sena Congress Sharad trio have a fighting chance? I'll let
Well, as far as the numbers are concerned, I mean, as far as the case is concerned, so far, definitely the fact that they are also fighting it so aggressively, the fact that they want that this should not become the precedent, like this is what the BJP, I mean, in their words, they are saying that if today nothing is done, then this will become the norm for the coming years as far as that is concerned, and which is why today they have also decided to parade all the MLAs. A show of strength will be done by them today at around 7 o'clock in Mumbai. They will get all their MLAs together and they will show that while on paper BJP might be claiming something else, but in reality the MLAs are in fact with Sena, Congress and Sharad Pawar-led NCP, and which is why, and this is also something that they want to show to the people, that while on paper BJP might be saying anything, but if you really get to the if you really try to see what exactly is going on, these MLAs are either being given this the lollipop of being offered plush portfolios or money, but in reality they are very much with the respective parties. So that is something that that will happen at 7 o'clock. Whether it will technically and legally change anything is something that you will be able to say that that is something that the Supreme Court has to decide, the legality of the floor test.
So basically, when we talk about they have a fighting chance or not, we have to look at all the points that they have been arguing in the petition. The primary contention, to sum all of this up, is that the governor acted in an arbitrary manner. The governor is not being able to cite any kind of emergency. In fact, Kapil Sibal has gone on record to say what kind of national emergency did India did fall on India that in the wee hours of morning was the president's rule revoked. And my colleague Neelam Pandey very correctly said they're very afraid that this would be the precedent, because whenever whether it be Karnataka, whether it be Goa, whether it be Uttarakhand, it's only in Karnataka, if I'm not wrong, that the Congress approached the Supreme Court because a similar post poll a similar post poll alliance was happening. However, they are very sure of this one fact, that they have also informed the Supreme Court that we did not claim the majority because we did not arrive at a common minimum program. So, they said that when we reached a common minimum program, that we held the press conference and then we had the numbers. However, a very strong counter argument on behalf of the BJP and the NCP-led Ajit Pawar is that, it was the 12th or the 14th of November when their time given to Shiv Sena and NCP was over. Since then to 22nd November, none of them went to the governor to stake claim to the or claim majority, etc. And they also claimed that this was the only letter written to Governor B.S. Koshyari staking claim to the government, showing around 170 member MLAs and saying that they have the majority. So this was the first letter which the governor had, and apparently it is the governor's subjective satisfaction upon receiving of a letter that he may invite anyone to form the government. So a lot of twists and turns, as my colleague also said, that around 7 p.m. they're going to have the parade of MLAs. So that is again one thing to watch out for, and we at ThePrint will be tracking it. So that is all for us. Please subscribe to our YouTube channel for more videos. This is Debayan Roy, Principal Correspondent, and this is Neelam Pandey, Senior Correspondent for ThePrint. Subscribe to our Instagram, Twitter, and all other social media handles. Thank you.